Finally, see the start. Mr. Deputy Chairman, Sir, in pursuance of the government's policy to secure the active cooperation and involvement of all democratic, secular, and progressive forces in the country, it was considered desirable to have a dialogue with Sheikh Mohammed Abdullah. Honorable members are aware that Sheikh Abdullah had played a notable part in the freedom struggle and in the accession of the state of Jammu and Kashmir to the Indian Union. He formed and headed the government of the state for a number of years after independence, despite the differences which led to the subsequent estrangement. It seemed clear from the public statements made by Sheikh Abdullah as well as personal talks with him that his commitment to basic national ideals and objectives had remained unchanged. He reaffirmed that the accession of the state to the Indian Union final and irrevocable. His main area of concern was about the legal and constitutional changes made after August 1953. It was decided that Mirza Afzal Beg, whom Sheikh Abdullah named for the purpose, and Sri G. Parasarthi, whom I entrusted with the task, should examine these changes in depth and make appropriate recommendations. After extensive discussions, they reached agreement on various points which are incorporated in the agreed conclusion, a copy of which is placed on the table of the House. These conclusions formed the subject matter of further discussions at a political level, in which Sheikh Abdullah and the Chief Minister of the state and Sardar Swaran Singh participated. As a result of these, an understanding has been reached as disclosed in the letters I exchanged between me and Sheikh Abdullah, copies of which are placed on the table of the House. I shall refer to certain basic features of the understanding. The agreed conclusions have been formulated within the framework of the Constitution of India. The constitutional relationship between the state of Jammu and Kashmir and the Union will continue as it has been, and the extension of further provisions of the Constitution to the state will continue to be governed by the procedure prescribed in Article 370. There will be no weakening of the ties which exist between the Union of India and its constituent units, of which the state of Jammu and Kashmir is one. The existing jurisdiction of the center to deal with activities directed towards questioning or disrupting the sovereignty and territorial integrity of India, or bring about secession of any part of the territory of India from the Union will also continue. It has also been agreed that any amendment of the constitution of the state on certain specified matters of importance will not become effective unless the assent of the president is obtained. The agreed conclusions seek to reassure the state that in case the state government comes up with any proposal to change any central law made after 1953 on matters in the concurrent list such as social welfare measures, cultural matters, social security, procedural laws and the like, the grant of assent to the bill will be sympathetically concerned. A proposal was made by Mirza Afzal Beg that the jurisdiction of the Supreme Court in relation to the state should be curtailed. This was not accepted as it is considered important that the Supreme Court should continue to have its original and appellate jurisdiction in the matter of writs, appeals and other matters. However, it was agreed by collateral letters that the provisions in Article 132(2) enabling the Supreme Court to grant special leave on the refusal of a certificate by the High Court need not apply to the state. Action on this will, however, be taken only when the state government comes up with a proposal in this behalf. Honorable members will notice that this question of nomenclature of the governor and the chief minister could not be settled. This is a matter which is provided for in the state constitution, which at present uses the expression governor and chief minister. A change in the nomenclature can be made only by amendment of the state constitution by the state legislature. So far as the chief minister is concerned, there should be no objection to the adoption of the designation prime minister in the state if the legislature of the state of Jammu and Kashmir amends its constitution accordingly. Until this is done, the present designation would continue. Sheikh Abdullah was also very anxious that to start with the constitutional relationship between the state and the center should be as it was in 1953 when he was in power. It was explained to him that the clock could not be put back in this manner. Mirza Afzal Beg pressed for the transfer of provisions relating to fundamental rights. Madam, I beg to move that the bill further to amend the Northeastern Areas Reorganization Act 1971 be taken into consideration. Madam, this is a simple piece of legislation which seeks to replace the Northeastern Areas Reorganization Amendment Ordinance 1975, which was promulgated by the President under Article 240 of the Constitution on the 20th January 1975 as a result of reorganization of the composite state of Assam under the Principal Act of 1971 as from the 21st January 1972, the Assam State Electricity Board and the Assam State Warehousing Corporation existing at the time in the composite state became interstate bodies corporate. A provision was made in section 53 of the Northeastern Areas Reorganization Act 1971 for the continued functioning of these two bodies in all the territories of the composite state, that is the present state of Assam, the state of Meghalaya, and the Union Territory of Mizoram. It was also provided in subsection 3 of the same section that these bodies shall cease to function and stand dissolved on the expiry of the period of 2 years from the date of reorganization or such earlier date as the central government may by order decide. Insofar as the Assam State Warehousing Corporation is concerned, the Ministry of Agriculture and Irrigation Department of Food, who are concerned with warehousing, have issued an order under subsection 3 of section 53 dissolving the Interstate Warehousing Corporation as from the 21st January 1975 after the intra-state warehousing corporation set up by the states of Assam and Meghalaya took over the undertakings, assets, rights and liabilities of the Interstate Warehousing Corporation relating to the warehousing centers functioning with the territories of the two states. It may be mentioned that there is no warehousing center in the Union Territory of Mizoram in regard to the Assam State Electricity Board. However, the Ministry of Energy, Department of Power, who are concerned with electricity boards, were holding discussion with the representatives of the governments of Assam and Meghalaya with a view to persuading the two states to evolve mutually acceptable arrangements for the future functioning of the electricity board step.